Hello, welcome to the Dread Lawyer channel. I am your host, Neil. Happy Friday to everyone. I hope you all have a great Labor Day weekend. As you can see, I didn't have any court today, so I didn't wear a shirt and tie. I'm just in a t-shirt and shorts, but I had plenty of work here to do today. So now that I've got my regular legal work done, I wanted to make this video as for everyone, as I do every Friday, on various topics in Virginia criminal law. And the topic I wanted to cover today is plea agreements. Plea agreements, in my experience, for some reason, get a bad rap. I found a lot of people don't really understand them and why we have them in our criminal justice system. So I wanted to make a short video on that. In order to explain plea agreements, first it's necessary to explain what a trial is. A trial is a judicial proceeding where either side or both present admissible evidence in a way that is persuasive to the judge in a bench trial or a jury in a jury trial. I often explain it in addition to that very simplistic explanation. I add this. And I'm sure some very learned practitioners or judges or academics would disagree with what I'm about to say, but trials in a criminal context are not about the search for truth. Remember, I said admissible evidence at trial. There's a lot of evidence that's truthful that cannot be admitted at trial for one reason or another. Plus, either side picks and chooses what evidence they wish to put in. So keep in mind, it's an adversarial process, but either side is free to pick what they want to put into evidence to convince the finder of fact, either that someone is guilty by proof beyond a reasonable doubt, or someone should be found not guilty because the government has failed in their burden of proof. Now that I've explained that, let me also add, and this is where I go to in talking and advising my clients, that a trial is a cost-benefit analysis. Going into a trial, you have to do a risk analysis with your client. What do they risk if they enter a not guilty plea and insist on trial? What do they risk if they come in and plead guilty and have to face a judge to sentence them? More often than not, the burden of risk is, the majority of it is on the defendant. I say that because, yes, the prosecution has risk, sometimes considerable risk. However, a prosecutor will come in, try a case. If they lose the case, they go home, they have dinner, they get up the next morning, and they come back to the office to keep working. If your client, the defendant, tries a case and loses, then more often than not, your client is going behind bars, or they're going to have their liberty taken from them for a considerable amount of time, or face financial ruin by fine, or both. So that's why I say that the risk tends to be more of a burden on the defendant. But that's what a defendant and a defense attorney in advising their client have to recognize, that a trial is about risk. And then how much risk does that defendant want to accept? And then in having that conversation, that's where the idea or the topic of, okay, let's approach the government and see if they're willing to negotiate, see if they're willing to find some middle ground that we can come to, that we can both be comfortable with, and that's the plea agreement. In my practice, I never utter the word plea agreement until I've had full discovery. I understand very clearly what the evidence is going to be, what possible factual defenses I have, or what legal defenses I have, or a combination of both. And after I've had the opportunity to talk generally in person, I prefer face-to-face conversations with my clients when I'm advising them and talk to them about all of that. Then and only then do we talk about a plea agreement. You need your client to trust you, to understand that you know what the case is about before you start talking about trying to come to a compromise. So when we talk about plea agreements are controlled by rule. So in the Virginia rules of the Virginia Supreme Court, criminal procedure rules, their plea agreements are covered under Rule 3A:8. I'm not going to read that rule to you. That's boring. Just suffice it to say a plea agreement is a contract between the prosecution and the defense attorney. If they're able to come to an agreement, that agreement is then presented to the judge. The judge decides whether to accept it or reject it. 98.5% of the time, the judge is going to accept it. Sometimes they reject it. If the plea agreement is rejected, then both sides are not bound by it. The defendant can then withdraw their plea, and the judge must recuse himself, and another judge will handle it. There can be a new plea agreement. The same plea agreement can be presented to a different judge, but suffice it to say that the judge that rejected the agreement must recuse himself. And here's a very, very important part of that. The judge can never, ever be part of the negotiation for a plea agreement, either explicitly or suggestedly. So in my experience, all the judges I've been in front of, if there's an issue with a plea agreement, the judge just leaves the bench and lets the attorneys solve it or work it out. Judges cannot get involved in plea agreements. Plea agreements benefit or are a necessary part of our criminal justice system. And when I say a necessary part, I'm not making a judgment call on them. They're just a part of it. Why do I say that? Putting myself in the prosecution's shoes, the prosecutors, they run a risk every time they try a case. There's no guarantee that they're going to get a conviction. And especially in a serious case, losing a case, getting an acquittal can be damaging not only to that prosecutor's office, but also to other law enforcement. So the prosecutors have to keep that in mind. On the defense side, as I've already talked about, they run a terrible risk sometimes if they try a case. For example, if you've got cases that have mandatory minimums or very serious cases like rape or murder or robbery, where you run a risk of getting a significant amount of time. There's a number of different variables that factor into negotiations between the prosecution and the defense. Suffice it to say, if they're able to come to, it can include what they're plead guilty to or no contest to, what they're convicted of, what level of offense, what amount of time that they might serve, what amount of fine that they might have to pay, or a combination of all of that. It's almost impossible to list all the variations because every case is different. But it's a necessary part because the prosecution wants to get something out of it. And not every case as charged is a true reflection of what happened in the case. That's why we have an adversarial process so that the prosecution's evidence can be rebutted. And more often than not, as the case develops, the defense attorney and the prosecutor talk about the case. The defense attorney lays out their side, without violating attorney-client privilege, but they lay out their side so that, the prosecutor knows here is the alternative explanation, here's the other evidence they don't know, or sometimes the defense attorney will point to problems in the prosecution case that could expose the prosecution's case to being undermined or crippled. That often, I've done that. That happens from time to time. there's no guarantee that the defense attorney would prevail if this issue or not, if that issue would be litigated. So those are all things that can be discussed as part of a plea agreement. So in the end, it's better to come away with something better than nothing, because you never do know what's going to happen when either side rolls the dice in a full-blown trial. For a defendant, when there is a plea agreement reached, the big benefit is they know first, they've had the opportunity to negotiate. They understand what the case is. And second, and perhaps most importantly, the defendant knows exactly what's going to happen when they go into the courtroom and the plea agreement is presented. So they know what's going to happen. So that risk is taken away. And I think, in my experience, that's the most important part of it for the defendant. So to wrap things up, plea agreements are allowed by law. They are in the criminal procedure rules in Virginia. They are a necessary part of our criminal justice system. It helps our system be flexible. It helps, and I didn't mention this, but let me mention this now. It helps also to save valuable or valuable resources for the Commonwealth. Commonwealth, they don't have unlimited personnel. They don't have unlimited time. They don't have unlimited money. So that's always a factor too. So there's always scarce resources. So to finalize, there's nothing wrong with plea agreements. They are not an injustice. It's not a cop-out. Sometimes it is simply the best way for a case to be resolved to the benefit of the Commonwealth attorney and also to the benefit of the defendant. So I hope that clears that up to anyone who watches the video. I appreciate you watching. If you like it, hit the like button. If you like what I'm starting to do here on my channel, as you can see, I haven't got that many videos yet, and I'm moving forward and trying to populate it as much as I can. I hope what I'm doing is helpful to people. So thank you for watching the video. Have a great Friday. Have a great weekend. Bye-bye.